All right, so that'll bring us next to Halderman et al. V. Bruckman, or Halderman v. Bruckman et al. File 24-9044CH. And we just did a courtroom renovation, and it looks great, but I do apologize. It doesn't seem to accommodate multiple counsel super well.
Thank you.
When we did Emmett County, it was unbelievable. They could make 2 out of the 3 courtrooms smaller. It's like, is that tax dollars at work or what?
Well, part of what we did, frankly, was we made the jury box and witness stand ADA compliant, and that took up more space into the well of the court. So something had to give, and it was either the judge's bench or the lawyers' or counsel tables. And so I suppose you got to show it. All right, so we are on my civil docket. I am providing public access not only in the courtroom but also online. Just want you folks to know that. And we are here today. Looks like defendants Bruckman filed a motion for summary disposition. I reviewed the plaintiff's response. Defendants Coveton and Cisco filed a response in support of that. Plaintiffs filed a motion to strike that initial response for seeking relief for those defendants without a separate motion. It looks like, and there's responses to that, motion strike, but it looks like defendants Coveton and Cisco filed an amended response that maybe fixes that problem. All right, so let's have counsel state your appearances for the record, beginning with plaintiff.
Yes, Your Honor. Joseph Zayas on behalf of Mr. and Mrs. Halderman.
Kevin Cleaborn, I represent Mike and Becky Bruckman.
Lawrence Hanson on behalf of Mr. Cisco and Mr. and Mrs. Coveton.
Okay. And is Richard Reeves present? No. And is Doris Reeves present? Oh, Mr. Reeves is representing himself, filed a letter answer. It wasn't signed by Doris, so there was a default entered on her, but they are both improper. Okay, so Mr. Zayas, I guess my first question is, does the amended response address your concerns? And we're not going to hear argument about striking their initial response.
Only if, Your Honor, that the the defendants aren't going to request summary disposition on their own behalf.
Well, I don't know, because I guess my other, and I don't want to jump the gun here, sure. I want to hear argument from all sides.
Sure.
But if Bruckmans are entitled to summary disposition, wouldn't everybody? I mean, these are co-tenants.
Right. I mean, there are some similar issues. I understand that. My real issue.
Similar? How would they be any different? The court rule says if I conclude that the facts are such that a party's entitled to judgment, then I should enter it without delay. So if Bruckmans prevail today, it seems to me all the defendants would prevail today. Why would there be any difference if they're co-tenants?
My real issue with the pleadings that the Coverns filed, Your Honor, was the fact that they added additional arguments. In fact, even adding additional case 3 days before my response is due. If they simply filed a concurrence saying exactly what the court just said, I think it'd be a completely different situation. But when, you shorten the time I have to reply by 2 weeks by adding additional arguments and even referring to another case, then I think that's a different matter. And that is my real issue with the Coverns trying to kind of add themselves onto this. It wasn't a simple, yes, we concur, us too. It was, here are these other arguments that why we should grant us summary disposition, which are not exactly the same as what the Bruckmans filed.
Oh, okay. All right. Well, and I know there was a response to your motion to strike, and so you all, or many of you, seem to care a lot about that. I want to assure you I care very little about all the details of when it was filed and whatever. I read all this stuff. You all did a great job filing all this stuff. So I am much more interested today in the, you can make whatever arguments you want to make. I am much more interested today in the substance on whether the Bruckmans are entitled to summary disposition. And it seems like if they are, that's the first domino and everything falls after that. So that would mean it's your motion, Mr. Cleveland.
Thank you again. Good morning again, Your Honor. It seems like from the plaintiff's view of the world, they pled adverse possession, hostility, et cetera, time and time and time again. But the facts at their depositions just shout loud that there is absolutely no element of hostility whatsoever. And any kind of claim like that has to be inconsistent with the rights of the defendant. And so, is there anything anywhere where the use of that drive was inconsistent with the rights of the defendants? And the answer is no. The issue of even the extension of that drive onto the plaintiff's property, Plaintiff Rich Halterman testified, well, I put that in for Mr. Covington's father, Grandpa Covington. He never said, well, I did it because I wanted to, I did it because I need to, or anything like that. The plaintiff, Julia Halterman, testified it was for the defendant's guests. And so even that extension of the drive onto their property from the upper level was not done under a claim of right. And so, you know, every case that's out there having to do with this type of prescriptive use claim has some kind of element of hostility. And there just isn't any. And so when we go back to the records that we attached to our motion, where the Bruckmans have records of gravel dating back to 1994, and then the plaintiffs have nothing. I mean, the only thing that they've produced with regard to any kind of documentary evidence at all is the purchase of an Argo and a Kubota side-by-side. And so it just seems to me that there's just nothing. And so when the plaintiffs admit, yep, we're friends and we do it all together, and they really have no comeback even to anticipating their best argument. Gee, we bought in 1984 in land contracting, so we were there before you. But when Mr. LeBron testifies, I put up a lock and cable while I was there for the 6 years, and I never saw the plaintiff using it at all. Again, there's no continuous hostile claim of right, 15 years, etc., that the plaintiff would have to establish to take away a property right of the defendants. And so, again, when I'm glad that counsel for plaintiff attached the deposition transcript of Julia Halterman. So at page 25 of the deposition, she testified when I asked her a question about, how does the whole gate kind of thing. She said, normally we'd ask them, meeting the competence, permission to open the gate. Can you please open the gate? We need to get down. Well, my goodness, there is no hostility at all. If they're best buds with a one-quarter owner.
The use of this, they announced that they were now claiming this is a hostile right. This is different than a neighborhood situation. This is more like a family situation. Can you have a family member living in your property with you for 25 years, file a claim for prescriptive easement to continue to stay in the property? I thought that the concept of unclean hands breaches that, which is why I briefed that. So I have nothing further at this point.
Okay. Thank you, Mr. Hanson. Mr. Zayas?
Yes, Your Honor, thank you. Again, Joseph Zayas on behalf of Mr. and Mrs. Holderman. And the first thing I think I want to point out is when counsel says that Mrs. Holderman testified about getting permission to go around the gate. That gate only went up 2 or 3 years ago. They have been using this road on a continuous basis for the last 40 years. And at the end of the 15-year period, that's when the right vests. So whatever happened after that gate went up is frankly irrelevant.
Well, I mean, it might not be dispositive, but it seems a bit much to say it's irrelevant, because if your clients had a claim, if she pulled up to a gate and said, open the gate so I can use this road, because it's, if it wasn't some asking permission, the asking permission is, if we have a trial, that would come in at the trial because it would be relevant, right?
Yeah, it would probably come in, but I would argue that it certainly, perhaps I misspoke, Your Honor, certainly wouldn't be dispositive of whether or not it was permissive use or not.
I agree, yes. Okay.
Frankly,
there's some evidence of it.
Maybe.
She's asking permission. Why is she asking permission if she doesn't need permission?
Well, frankly, I would argue, Your Honor, that that's more trying to keep the peace between the parties after they have kind of staked their claims and we filed a lawsuit trying to get this than anything else. I know the court certainly disapproves of self-help tactics. And once the gate went up, my client simply said, okay, we're going to exercise our rights under the court to try to get access to this road again.
Okay.
Now, my argument, Your Honor, is that at 15-year period, their rights vest. So, it's not evident, or it's not evidence of permissive use within that first 15-year period, certainly. And I think that's important to point out. So, the most important thing here is I think we need to realize that we must take the facts in the light most favorable to my clients. We're looking for questions of fact here. And I think when you take the evidence in the light most favorable to Mr. and Mrs. Holborn, we see that they've been using this path since they purchased the property in 1984. They both testified very clearly to that. Now, counsel has attached an affidavit from a prior owner saying, well, he put up a string, he put up a gate. He certainly didn't, confront my clients with that affidavit during their deposition. If anything, he's created a question of fact because my clients were very, very clear that they used that continuously since they bought the property in 1984 when they started to clear their property. So taking those facts in the light most favorable to Mr. and Mrs. Holderman, it establishes that they started to use that they continuously used that property. Now, if anything, what that affidavit does is show that that use was hostile. It certainly shows that the prior owner didn't give any sort of permission for them to do so. Nothing within the affidavit suggests such a thing.
But even if you were right on that, that wouldn't establish the 15-year period is not established just through that.
No, I'm getting there.
So then, how do you overcome the whether you call it permissive use or it wasn't hostile, it's sort of two sides of the same coin, where here's this outlot that by deed doesn't give your clients a right to use it. It gives these other folks a right to use it. And those other folks and your clients together are improving the roadway. The owners are buying the materials and your clients doing some grading. They're all kind of using that together. How does that ever establish or ripen into any kind of hostile use? It seems at least some, even were there no words of permission, which there are some words of permission in this record, even if there were none, wouldn't that be a pretty clearly implied permissive use?
No, Your Honor, and I'll tell you why. Because cooperation does not equal permission. And there's no case law that says specifically that if the parties cooperate, that it has to be a permissive use as a matter of law.
Sure. I don't necessarily disagree with that, but as a matter of fact here, I mean, how is cooperative use inconsistent with the rights of the true owners or hostile to the rights of the true owners?
Because the Holdermans, in using this continuously since 1984, were doing so as if they had a complete right to do it. And nothing that the defendants did changed the manner in which they were using this, which was under a claim of right going back to 1984. So simply because the defendants get there and see the Holdermans using this prior, because I think the record is clear that the Holdermans were there before, simply because they were there before, simply because they said, okay, so you're using it, we're using it. If you do this, I'll do that. Let's come to an agreement on how this is all going to be maintained so we can have this great, happy lake life. That in and of itself doesn't change the claim of right that my clients had previously established. No time did the defendants in this action say, at least according to my clients, I know there's testimony on the other side about this agreement that they reached, which is slightly different than what counsel represented. It wasn't, we'll buy the things, you do the maintenance. The agreement that the defendants tried to push was in exchange for letting you use the property, the lot, this is what we'll do. This is how we'll maintain it. Well, my clients denied that that agreement ever took place. That being said,
the defendants, Bruckman, argued that this use was permissive, and they have depositions from several of the defendants that support this, depositions from other parties that are consistent with that theory as well. For example, about the road being impassable during certain time periods or not being used by the plaintiffs. The Bruckmans also say that the plaintiffs were allowed to use the access road.
The ruling comes down. The judge says the Holdermans simply didn't meet the legal bar. Their use looked permissive, not hostile, and they offered no solid evidence to contradict the defendant's survey on dock trespass. Result, summary, judgment for all defendants. The Holdermans' claims are thrown out, and only one question remains. How much in damages for the dock trespass?
The access road in exchange for performing grading work on it, although defendants purchased the materials and then plaintiffs did the work, and the defendants have presented documentary evidence to support that arrangement. It's also undisputed that the relationship between the plaintiffs and at least some of the defendants was quite close over the years. Plaintiffs respond by saying, well, there's no agreement or permission to use the access road, and hostility for purposes of a prescriptive easement is not the same as emotional hostilities. That of course is true, but the hostile use must be inconsistent with the rights of the true owners, and it must be apparent that it's under a claim of right, and has been pointed out by counsel, it must be of the type of use that it would place the world and certainly the true owners on notice that this was happening. Here, the facts don't support this. The defendants have brought forth several facts, testimony, records of material purchased, affidavits about the installation of the access road and the lack of use by plaintiffs prior to that time. And plaintiffs have really done little more than simply deny that such an agreement took place. That is insufficient for the plaintiffs to meet their burden of establishing a genuine issue of material fact. Indeed, plaintiff's own testimony suggests the existence of permissive use. Plaintiff Richard Holderman said the only person who gave him permission was defendant Chuck Coveton. Even if that was the only co-owner who gave permission, that alone would establish that the use was permissive, not hostile. Also, the defendants have shown a clear, defendants Bruckman have shown a clear trespass of riparian bottomlands of the plaintiff's dock. They've got the riparian survey documenting that, and plaintiffs have not raised a genuine issue of material fact to dispute this. They just disagree with the survey, but have presented absolutely no contrary evidence. Therefore, there's no genuine issue of material fact. Defendants Bruckman are entitled to summary disposition under MCR 2.116C10 of plaintiff's claims in the complaint, and they are also entitled to summary disposition under C9 for their counterclaim of trespass, except as to damages. So then we've got other procedural issues. The Coveton and Cisco defendants have concurred in Bruckman's motion. Their first response also affirmatively asked for relief from them, and the plaintiffs objected to that, and the Coveton and Cisco defendants filed an amended response. But in any event, MCR 2.116I provides that if the proofs show that there's no genuine issue of material fact, the court shall render judgment without delay. So requiring other parties to file motions that would lead us to the same point that we are today would be contrary to the intent of that court rule, and it would be contrary to sound concerns about judicial economy and litigation costs for the parties. So here, all the defendants, although not jointly represented, have the same property rights. There would simply be no way for the plaintiff to prevail against some, but not all of them. Therefore, under 2.116I, and in the interest of judicial economy, the court is going to sua sponte set aside the default against Doris Reeves and grant summary disposition to all defendants. Bruckmans may submit an order. Mr. Cleaborn, as the prevailing party, you can submit an order to that effect.
we'll do so.
And then the only remaining issue will be damages for riparian trespass. So we should set that for a final pretrial. So why don't we schedule final pretrial October 13 at 9:10 a.m.